Would there be a difference if a race is a tight race? Because it seems as though the problem we're having here is that there's an argument that there was no risk that this candidate would lose.
Justice Thomas, we do not think it would matter if it's a tight race. If a candidate, in this scenario, the candidate is a direct object of the ballot counting rules. And what this court's precedents teach is that when a candidate is a direct object, a small probability of risk is deemed to be a substantial risk. And the example we use in our brief is the example of a Russian roulette hypothetical. Even if the risk that the round in the chamber is live, the very fact that in that context, the direct object of the game is being forced to engage in that game means he has a concrete interest, means he has standing to prevent that risk from happening.
Well, but when you put it that way, it seems to me that you are kind of buying into what risk does the candidate really have. I mean, in Russian roulette, you've got a 1 out of 6 or whatever it is risk. But if you're looking at risk and it's 85% margin of victory, I mean, is that your argument?
Our argument is that the substantial risk test in this court's precedents goes to the question of whether a risk is speculative or not. So in the context of ballot counting laws, we know that the law is going to be applied to the candidate. We know that the law's purpose is to determine which candidate wins, so it's targeting the candidate's concrete interest in winning his election. And so therefore, there is an actual risk that those ballots could sway the outcome of the election. And a candidate—
what if there isn't such a risk? He's won 10 elections in a row by 85%. Maybe you can even tell from the turnout before the mailing in. I mean, does that make a difference under your theory?
It would not make a difference, Chief Justice Roberts. We pull this test. It comes from this court's pre-enforcement standing context. In that context, this court has deemed a risk to be substantial even if there is something like a credible threat of enforcement, or if the threat of enforcement is not imaginary or wholly speculative. The court's never put a probability threshold on the
Yeah, but I would say in my hypothetical, none of those adjectives fit it. There isn't a credible threat that the guy is going to lose.
But it's still, I mean, it's part of the issue is past results don't guarantee future outcomes. So even in the Russian roulette hypothetical, even if it's a 1 in 100 chance, the fact of the matter is a person is forced to engage in that gamble, and the concrete interest and the what's it to you answer is avoiding the gamble that implicates that person's concrete risk. A candidate is in a similar situation because ex ante, this ballot counting rules force them to take the risk that those ballots will sway the outcome of their election.